All right, welcome to the House Environment and Transportation Committee for Thursday, February 19th, 2026. We are going to start with House Bill 474, Delegate Patterson and Lucy, Clear Before You Drive Act. Delegate Patterson, if you have a panel, please bring them up.
Thank you very much. I don't see what she's talking about this. Oh, that's great. Good afternoon, Chair Corman, Vice Chair Guyton, and members of the House Environment and Transportation Committee. For the record, I'm Delegate Edith Patterson, sponsor of bill entitled Vehicle Laws, Dangerous Accumulations of Snow and Ice, Removal from Exposed Vehicle Surface. In other words, House Bill 474. Winter driving presents serious challenges, and those risks increase significantly when snow and ice are allowed to remain on vehicles. Many drivers clear only their windshields and windows, but snow and ice left on roofs, hoods, and trailers can fly off during transit. When that happens, debris can impair visibility, damage vehicles, and cause serious crashes. This bill addresses these public safety concerns. The legislation prohibits a person from operating or towing a vehicle when snow or ice remains on exposed surfaces in a way that contributes to an accident resulting in property damage, serious bodily injury, or death. Penalties apply when actual harm occurs or as a secondary offense, making this a specific targeted safety measure rather than excessive enforcement. We have worked closely with the Maryland Motor Truck Association for recommendations to accommodate their concerns and have come to agreement with a few amendments that you will hear later. This will improve the legislation. We are confident that this bill will strike a fair balance between safety and practicality. After a preventable and tragic death caused by ice flying from a vehicle and striking another driver's windshield, Pennsylvania enacted Christine's Law, named in honor of this victim. I have a statement from the husband of Christine I will share with the committee later on because he describes the incident that happened and the trauma it caused not only himself but his son as well. In fact, Christine's untimely and tragic death as a result of ice flying from a truck and instantly causing her death. After a preventable and tragic death caused by flying ice, etc., this law, Maryland's law, has already made significant incidents where flying snow and ice have led to crashes and injuries. This legislation gives us the opportunity to act before a life is lost. We should not wait for tragedy to force our hand or for this bill to carry the name of another Marylander taken too soon. Taking action now will improve road work, safety during winter weather, and help prevent needless loss of life. And I will thank the weather conditions that we had a few months ago to attest to the need for this legislation. I'd also like to publicly thank Kara Franklin for her research and advocacy on behalf of this legislation. And for those reasons, I offer and request a favorable report on House Bill 474. And Mr. Chairman, I have several guests who will offer their testimony. Thank you.
Please go ahead when you're ready.
I could start?
Please do.
Okay. Hi, my name is Lucy Goldband, and I'm in 3rd grade at Burning Tree Elementary School. Last winter, my dad and I were driving in the car on the highway, and and the car in front of us had snow and ice on its roof. It flew off. My dad had to swerve to get around it, and it scared me. I asked my dad why they were allowed to have that up there because it was so dangerous. We got home and looked up to see if there was a law about this and found out that there wasn't, even though it's not allowed in other states. We think that people need to clear the snow off their cars so that accidents don't happen. Even if you don't want to clear the snow off your car, the most important thing is to be safe. Which is worse, having to spend a couple of minutes clearing snow off your car or damaging someone else's car and causing an accident? I don't want anyone to get hurt, especially for something that we could control. This is why my dad and I wrote to Delegate Corman to try and get this changed. Please vote for the Clear Before You Drive Act to keep kids like me and everyone else safe on the road.
Good job.
Great job, Ruth.
All right, Regina, good luck following that.
Yes, right? Oh, my gosh. She said everything I was going to say, Mr. Chair. Me too. Good afternoon, everyone. For the record, Regina Ali with AAA. Good afternoon, Mr. Chair, members of the committee. AAA is certainly here in support of House Bill 474 for Clear Before You Drive Act. And we certainly appreciate Delegate Patterson and the other sponsors for bringing this bill forward. Following the little young lady over here, she's absolutely right. And the reality is most drivers do clear their windshields and the rear of their cars when there's some snow and ice. But what we often see at AAA and law enforcement sees as well is that people fail to clear off the roof, the hood, and many times the lights, certainly decreasing visibility, not only for other drivers to see them, but decreasing their own visibility. I think we can probably all attest to, especially with the horrible winter weather we've seen over the last month, that you could very easily be driving and literally I will see someone and move over as quickly as I can when I see all that snow and ice on the top of their cars, because we certainly know that it can be very dangerous and certainly impairing the visibility of drivers behind them or to the side of them. Certainly we saw at least 2 incidents that made the news last month as a result of the weather. One in Anne Arundel County where a deputy's vehicle was struck and I believe the windshield shattered and he sustained injuries. And also in my county of Harford County where 2 people were injured on the Tidings Bridge, again as a result of snow and ice falling off of another car. So AAA certainly believes that House Bill 474 will reduce serious crashes caused by snow or ice becoming dislodged from motor vehicles and will save lives, protecting drivers and all road users, excuse me. As a matter of safety, courtesy, and common sense, we respectfully request a favorable report for House Bill 474. Thank you.
Thank you.
Thank you, Mr. Chairman. That's why I slid the microphone over to Regina before myself. For the record, Louis Campion with the Maryland Motor Truck Association, and we are here supportive of this legislation and really appreciate the sponsor working with us. We actually worked on this 10 years ago, in fact, because we acknowledge that falling snow and ice from all vehicles creates a dangerous situation. We've actually studied this issue back to 2008 because it is a more difficult situation to come up with solutions for large commercial trucks. But it is a safety issue and we want to be part of the solution. It's a safety issue for us and it's a safety issue for all drivers. A number of northeastern states have actually passed similar legislation. For example, you already heard about Pennsylvania, New Jersey, Connecticut, Rhode Island, Maine, and other states are using provisions like unsafe driving or load securement laws to try and enforce them if they don't have explicit rules on the book. The amendments that the sponsor has offered and that we worked with her on, just for clarity, really 2 key provisions to those. Number 1 is that it ensures that drivers are not forced to violate other workplace safety rules, for example, like OSHA and MOSHA rules, to try and clean off their trucks, because it is much more difficult, obviously, for us. And then it clarifies that if you have an incident that results in, striking another vehicle, then you're subject to the full aspect of the rules. But the provision around secondary enforcement, it just says that a driver cannot be cited more than once in a 24-hour period for the secondary enforcement violation, just trying to recognize that drivers who are out on the road do not have an opportunity to pull off necessarily, and you've got to give them time to get to a rest area, to get back to their terminal, so they can take those steps. So with that, we ask for a favorable report. Thank you.
Great, thank you. Louis, I know you worked with Delegate Patterson, which I appreciate, but did you check with Lucy on your amendments?
I did not. I absolutely should have that.
Okay.
Next time.
Question from Delegate Lewis.
Thank you so much, Mr. Chair. Thank you, Delegate Patterson, for bringing this bill, and thanks to your panel. Just point of personal privilege, I'd like to nominate Lucy as the honorary delegate for the day. She did such a good job.
That sounds great. That sounds great.
Oh, wonderful, wonderful. So I did have a couple of questions about this bill, which you've argued very well and which seems very much needed. My questions are these. First, what would be the mechanism for commercial trucks and private school buses, both of which wrote in with favorable with amendments? How do those vehicles clean snow and ice off? And Mr. Campion, you might be best for that.
Thank you, Delegate. That's a really challenging issue. In fact, there are a variety of mechanisms that can be used. If you have your own terminal, for example, they have ice scrapers that you can drive under. There are things called snow rakes. Snow rakes can be very effective at removing snow, but not ice. It is an ongoing challenge, which is why we've been trying to study it for so long, about how even truck washes can be utilized. The problem is, honestly, there aren't enough of them, right, to enable the trucks to get through and to utilize those. And it also doesn't address challenges of driving while you're out on the road and you get caught in a snow or ice situation, for example. So it is an ongoing issue. We think that, this is also an awareness benefit relative to compliance and taking steps to make sure that drivers are operating with clear vehicles, because we do want to acknowledge that safety issue. But it is a challenge for us in a way that doesn't exist for passenger car drivers.
So there's basically, for the average commercial truck driver, I know you don't speak for the private school buses, but just to give an example, there's really no way, a feasible, reasonable, accessible way for them to clear snow and ice off.
Well, that depends on at your terminal if you have one of those.
I'm sorry, Mr. Campion. What do you mean terminal? Sorry.
I'm sorry. So your depot, your location, for example, right, where you store your trucks. So for a long haul driver, it's a much more challenging issue, right? Because they're going to be out on the road for days or weeks on end, and not necessarily have that kind of access. For someone who is returning to and from the same physical location, which is the majority of activity that we do have. Most of our trucking operations in Maryland are regional or local in nature. Then your company would have to explore some of those options that are available.
Okay. So it's not easy. Thank you for explaining. And then my second question has to do with enforcement. So how would that work? Big concern I have would be a potential increase in police interactions. And we've worked so hard in this legislature over the past several years to minimize police stops and all the potential risks that might sometimes flow from that. What do you envision in terms of enforcement, Delegate Patterson, or anyone who's best to answer?
The enforcement, according to in the bill, it says enforce a violation only when it is a secondary offense. That is not to say everyone would be stopped or offered an offense if it's first. As a result of, for example, if there is a violation cause of an accident or bodily harm, then it would be considered an offense.
Okay, so if the driver's being pulled over for another reason,
Absolutely.
A broken tail light or driving erratically or something.
Right.
Okay, all right. Well, thank you. Thank you so much.
Well, thank you. And I'd like to also acknowledge Chair Corman for providing me this bill to sponsor.
Everybody hear that while you're asking questions? Delegate Foley.
Thank you, Mr. Chair. I have two questions, if I could. My first question, before I ask it, I just want to say, Lucy, thank you so much for such great testimony here today, telling us about why we should consider this bill and pass it, and I really appreciate it. My first question is for you. Do you and your dad clear your own car before you go out on the road? And if so, how long does it take you to do that?
We do clear our car, and wait, how many minutes does it take?
How long does it take?
5 to 10 minutes.
And it takes like
Depends on
5
how
to
much
10
snow.
minutes.
5 to 10
Depends-
minutes, that's
yeah.
all, right?
Yeah.
Okay, thank you for that, and thank you for being here. And my second question, it's so great that two of my favorite advocates support this bill. The motor truck folks and the towing professionals both support this bill, so that's great. But my question is for the sponsor, which is, Delegate, it does say that if you're towing a vehicle, you also have to make sure that it's cleared. Who's responsible for clearing that vehicle? Have you had any discussions or thought about that?
I'm not.
Oh, no, honey, I think that's for Delegate Patterson.
Maybe somebody else knows the answer to that. I'm just, because, is it the owner of the vehicle's responsibility or is it the tower's responsibility? That's my question.
Go ahead. You want to go first? Sure. You guys have a tow company.
I'm going to turn it over to Lucy for a reply, please. So at AAA, when we respond to a call for service, we ideally would request that the driver already have their vehicle cleared. However, if it is in a position where it is unsafe for them to do so, our drivers will take on that responsibility.
Okay, thank you.
Sure, thank you.
Delegate Naraki.
Thank you, Mr. Chair. Louis, this one's probably for you. So kind of thinking about all different kinds of loads. I mean, you guys haul all different sorts of things. It's not always just a trailer. So what happens in that circumstance? Because I'm not really sure that the bill speaks to what happens if we have like a ton of backhoes sitting on top. Like the trailer bed might be clear, right? But then there could be all kinds of stuff, sitting on that. And I don't think it really talks to that. And do your amendments address like those kinds of concerns?
They don't address specifically around, loads, for example, that would be hauled on a lowboy or a flatbed, for example, where like in your situation where they're hauling heavy equipment. But I do think that they address some of the expectations around what steps that you have to take to try and make sure that the load is clear. You've brought up an example that we sort of struggle with on this bill, which is with the Port of Baltimore, because containerized cargo, those containers just sit at the port for days on end before they're picked up. And we're actually prohibited from getting out of our trucks or taking any steps on the port terminals to actually clear. You're not even allowed to get out of your vehicle. And so it does pose some challenges, but that's why I think the amendments as they've been structured at least offer some protections against sort of unreasonable enforcement, I'll call it, where it may not be as simple as a passenger car.
Okay, I'm still concerned because I watch DOT pull folks over all the time in Baltimore County, and they're doing their job. They're doing what they should, but I'm concerned about what could come from that without kind of clarifying different load types and things like that, because there's certainly types of loads that are just impossible to clear off, to be able to even attempt to clear off. Some of the stuff that y'all haul around, you're not running through a wash or anything like that. It's just not possible to do. So I think there might need to be some thought about how that looks.
So then if I can delegate, Mr. Chairman, I think that's why the secondary enforcement aspect is a very reasonable compromise on this bill, because you would have had to have had some other instance for law enforcement to stop you, whether that be a brake or a taillight or any kind of issue there, before they would cite you, unless, of course, an incident actually occurred that caused, the kind of damage that we might be talking about, in which case you'd be cited anyway.
Okay, thank you.
Absolutely.
Delegate Healy.
Thank you very much, Mr. Chair. And thank you for the bill and for your delightful panel. All of you are delightful, but Lucy especially.
You're welcome.
I do want to ask, about like your homeowner, just somebody who, an average person who has a car, their own personal vehicle that they need to clear, and they absolutely should. But listening to all this discussion about how difficult it may be, I think about somebody who has got an SUV and maybe they're like not quite, maybe 5 feet tall or 5'1", and even with a long broom, may not be able to reach all the way across the roof, even from going from both sides and still leaving a little lump in the middle. How do you accommodate for, people who really try to do the best they can, but may not be able to 100% clear things?
Sure. Thank you for that question, Delegate. I fall into that category, that little person trying to clear the top. I think what I like about this bill, and I believe it's part of the amendments, is that you're required to make reasonable efforts to remove from exposed vehicle surfaces accumulated snow and ice. Reasonable efforts. Obviously, that can be somewhat subjective, but I think there's a difference in law enforcement. As you all know, I'm a former law enforcement officer, can clearly determine just by sight if someone made an effort to at least remove some of that snow versus a mountain of snow on top of a vehicle. So I think that the language requiring it to make a driver or a motorist to make reasonable efforts is key, but I think it's incumbent upon all of drivers to make that reasonable effort, because unfortunately, we've seen how dangerous it can become if those efforts aren't made.
And may I add that it's only with a secondary offense. You're not fined if you do not remove the obstruction, the snow and ice. It's only if there's an offense that occurs.
Thank you so much. Appreciate it.
If I were you, Delegate Healy, I'd call Delegate Morgan to get some help. That would be my advice. Lewis, I do want to follow up on Delegate Naraki's point, because I actually think the bill is much narrower than maybe that back and forth made it sound. It requires the clearing of the hood, the trunk, the windshield, the windows, the roof, the cab, and the top of a trailer or semi-trailer. So if you're carrying a dimensional load that doesn't fall into those categories, this bill doesn't require you to clear those. It's just the current law, which is no clearance requirement. Is that right?
That's a great point, and I should have made that observation, Mr. Chairman. I'm glad that you pointed that out. So thank you for doing that.
Great. So Delegate Naraki's question is basically inapplicable. It's just the current law would continue to apply. Is that right? The current law would continue to apply?
Oh, yes, sir. Thank you, Mr.
Okay,
Chairman.
great. Any further questions? Okay, thank you so much for this panel, especially the youngest member, our
Thank
junior
you for
delegate.
having me.
Absolutely. We do have another witness on this bill, John Seng from the Maryland Coalition for Roadway Safety.
You can sit here.
Oh, you want me to stay? Oh, you do.
Thank you, Chair Corman. John Seng, you've already introduced me, and I'll keep my remarks brief, and I'm noting the age discrimination here in the panel and all the applause. I don't expect an applause, that's fine, but I'm delighted to rise in strong support of this. Oh, thank you very much. I do appreciate that. I think, just want to ask a simple question. On a public roadway surrounded by other human beings traveling at 60 miles per hour, is there any clearer way to say, I don't care about physics and I don't care about you, than driving off the frozen glacier on top of your car? We've all seen it, a sedan cruising down I-95 with the snow cap thick enough to qualify as mountain terrain, a pickup truck shedding ice like it's participating in a winter parade. Then at highway speed, this snow turns into an ice missile. We've already heard about the crashes that have occurred because of this. And one of the, I guess, perks of being a final witness is you get to hear the preceding testimony. So let me just comment as a former John Deere tractor operator in a much earlier iteration of my life. Snow happens. And when we had our Snowmageddon here, 3-4 weeks ago, we heard about it for days in advance of all this snowfall coming. So we had the time to benefit from these forecasts. We believe, Safe Roads Maryland believes fervently that vehicle owners and operators have a primary responsibility for doing whatever it takes, covering their vehicles, shrouding loads, whatever the loads are, whatever the irregular format of. I sat there as I heard some of the concerns and maybe objections that, but it seems to me that de-icing agents, whatever, again, tarps, battery-operated snow blowers. You know, we know the snow's coming, and if I were an operator of a vehicle, I would get out there and blow things off if my delivery had to be there on time. So anyway, we stand in strong support of HB 474. Thank you.
Thank you. I do not see any further questions. That concludes the bill here, House Bill 474. We'll turn to House Bill 639, Delegate Charkoudian, Aviation Health and Safety Act. If you have a panel or anything, please bring them up.
I do have one person.
All right, thank you. Mr. Chair, colleagues, members of the committee. For the record, Delegate Lorig Charkoudian requesting a favorable report on House Bill 639, Aviation Passenger Health and Safety Act of 2026. So this bill has come to my attention. This bill, I just want to start by saying this is a broad bill that increases the safety of passengers traveling through any airport in the state of Maryland who are traveling involuntarily and in restraints. And so that could be the safety of individuals who are under arrest and being transferred to another state on a detainer by Maryland State Police. That could be individuals who are being transferred by the FBI. It could be individuals who are being transferred with immigration and immigration enforcement. It's come to my attention the fact that we need more protections as it relates to people traveling with restraints recently because, of course, there's just been so many more passengers, flights coming through our airports across the state with people in restraints because of the nature of the immigration enforcement and the way that's been working. And so this bill sort of gets at three aspects that I think are very much in Maryland's interest to address. So the first one is a pretty straightforward one, but first I need to back up because I've learned a lot about airports and how they operate. You all may know all this, but in general, you have the airport terminal, which is under the jurisdiction of the state. You have the tarmac, which is generally under the jurisdiction of the Federal Aviation Administration. But then you have what's called fixed-based operators and aviation service agencies, who are companies that have a contract actually with the state, with the Maryland Aviation Administration, and so are under the jurisdiction of MAA and service the planes that are that would come onto the tarmac, which is governed by the FAA, but it would be serviced, it would be refueled, it would be cleaned by a fixed-based operator who's under the jurisdiction of the state of Maryland. And so with that in mind, I think that's a really important distinction. There's obviously questions about jurisdictional issues that have been raised. So I just want to distinguish between what this bill, the angle that this bill takes. This bill is about our relationship, our contract, and our oversight of the fixed-based operators that the state has relationships with, the Aviation Service Administration, the state has relationships with. So the first thing that this bill does is it says, that a fixed-based operator may not refuel a plane with people in restraints on the plane. Now, in general, it is best practice not to refuel a plane that has anyone on that plane because of the heightened likelihood of an emergency. However, the guidance, the federal guidance, is that if there are people on a plane during refueling, they should not be strapped in. That means they actually take their lap belts off because you would want to be able to evacuate that plane in 90 seconds. So if you imagine now you have people in restraints on a plane, you definitely it's much more restrictive than a lap belt, and you definitely could not evacuate that plane in 90 seconds should there be a problem. So the first part of the bill is related to removing people who are in restraints from a plane for the purpose of refueling, making sure they're in a climate-controlled environment, not standing on a tarmac, and then putting them back on after the refueling is done. That's part one of the bill. The second part of the bill gets at the fact that should there be a medical emergency on that plane, even though those individuals are in custody of the state police or the FBI or ICE or whoever has custody of that plane, it is the Maryland emergency responders and Maryland hospitals that will need to respond to that emergency. And so this is really important. When people are traveling involuntarily, they may have medical conditions that might otherwise have kept them from getting on a flight at all because it increases the likelihood of some kind of a medical emergency. We know that things like blood clots increase in the air, so there's people who don't fly because of their pre-existing conditions. And certainly when people are flying in restraints and involuntarily, there's a higher likelihood that they could have a medical emergency with pre-existing conditions that would then be in our state to have to respond to. And we certainly want to maximize the likelihood that our medical responders, both EMTs as well as the hospital, have the ability to treat that person and maximize the likelihood of their survival and their health. So the second part of this bill says that before a fixed base operator serves an airplane, they need to make sure that they can see, they don't collect the forms, but they can see that there are forms on board in which people have had a chance to indicate if they have any pre-existing conditions, if they're a juvenile, that they have a guardian that could be contacted, if there's a need for some kind of medical intervention, if they're not traveling with their guardian, or a lawyer, depending on the status. And so the fixed base operator would make sure that those are on board. Again, hopefully there won't be any emergencies, but should there be a medical emergency, our physicians and medical personnel in this state would be able to respond to it. And the final thing that the bill does is it says that a fixed base operator shall not provide service to a plane, refueling, cleaning, or otherwise, unless they can, if people are traveling in restraints, unless they can see that there is a judicial warrant for everyone on the plane. And this raises a really important question. If there is a private flight, a chartered flight coming through, and there are people who are being trafficked, for example, so they're flying involuntarily, they're in restraints, do we want companies that have a contract with the state of Maryland to go and facilitate that human trafficking, facilitate a kidnapping, whatever it might be? And so, again, assuming that every agency that is properly flying people in restraints through our airports would have a judicial warrant justifying their ability to fly those people through, this shouldn't be a problem. They would simply show that they have the judicial warrant to the fixed base operator, and the fixed base operator would continue to service that plane. So those are the three things. We believe it'll increase the safety, decrease liability for the state, and we urge a favorable report.
Yes, good afternoon, Chair Corman, Vice Chair Guyton, and members of the committee. My name is Laura Atwood. I'm a longtime Maryland resident, and I'm testifying today on behalf of the Maryland chapter of Doctors for Camp Closure. This is a nonpartisan organization of over 2,200 physicians and healthcare professionals from multiple specialties who oppose inhumane detention and related practices. We urge a favorable report on this important health and safety bill. As an inpatient physical therapist with a clinical doctorate, I've spent my career focused on the interplay between mobility and other aspects of health. For the general public, flying has real risks due to immobility combined with the impacts of low cabin pressure and dehydration from dry air and often reduced fluid intake. I personally know 4 people who've developed clots to the lungs while flying in the last year alone. Detained people have compounded medical risks due to the common numbers and lengths of flights, often deplorable sanitary conditions during and between flights, and especially the use of 3-point shackles. These are handcuffs and ankle irons, each connected to waist chains. The shackles themselves are famously painful, further reduce mobility, and can cause multiple injuries, including severe bruises, cuts, swellings, fractures, and permanent nerve damage. Sometimes even worse, straitjacket-like restraints are used. And people on, I'm not sure about other systems, but on ICE flights, people remain shackled throughout their flights and often throughout the entire journey. At BWI, the number of flights of shackled people has risen dramatically in the last year. We must be prepared for when, not if, people come to us in dire condition. As a medical professional, I believe Maryland must take all reasonable steps so our emergency providers are equipped to do their jobs. As a taxpayer, I also don't want to have to pay damages if the state fails to act responsibly. I therefore urge the committee to make a favorable report on HB 639. Thank you for your time.
Thank you. We have a question from Delegate Frazier Hidalgo.
Thank you, Mr. Chair. For the bill sponsor, do you know what the average or range of time it takes to refuel these planes?
I don't, actually.
Okay, thank you.
Delegate Naraki.
Thank you, Mr. Chair. I guess this is probably for the sponsor. I'm looking at some documentation here that seems to indicate that there's a preemption issue here for the federal government. So how do you describe that? How would you say that this gets around that preemption issue? Because what I'm looking at seems to be pretty clear that we can't regulate this as a sole, purview of the federal government.
Yeah, I'm not sure which documents you're looking at. The opposition testimony, is that what you're looking at? Or
Yeah, I'm
what are
looking
the
at some of
documents?
and some case files and stuff that were sent to me from,
Sent to you from, sorry, case files of?
There's different there's different cases
Yeah.
that address this over the years, things like this about airlines, federal cases that address this. So I'm
Yeah.
just kind of.
Well, I guess the reason I'm asking what documents you're looking at is because I think generally if we were to start writing laws for what can and can't happen on our tarmac, that would be preempted. That is Federal Aviation Administration authority. The specific approach in this bill is that we're engaging with what fixed-based operators who have a contract with the state of Maryland can and can't do. And it's not clear to me, I've had multiple conversations with people who have raised that issue, had some engagement with the Attorney General around this, although I'm waiting for as I was building this bill, I had some back and forth with them. I'm waiting on a final sort of analysis of this bill. There's some of the pieces that got drafted, not exactly the way I wanted, so I think there may be some drafting pieces that need to be tightened up. But it's not clear to me that there are actually any case law that limits the ability, for example, of a state to say you can't refuel a plane if people are still on board. For example, especially given that national best practices is that people should be able to evacuate that plane in 90 seconds. So I think it is a complex area, but I do think that this is different from many of the cases that people have shown me or talked to me about that tend to be about telling the flight itself what it can and can't do, as opposed to telling the operator with whom we have a contract what they can and can't do.
Mr. Chairman, I have a follow-up. So another question I have is about the medical records in particular. So who would be responsible if we're gathering medical information about someone? Who's responsible for that? How are we ensuring HIPAA protections? I don't see anything about HIPAA inside of the bill here to ensure that. So I'm curious who would be the ultimate, maybe it's the airline initially, but who is the ultimate holder of those records?
Yeah, it's a great question. And it's a little bit tricky because there's this question about who's engaging with the people on board and then who ultimately would have to care for them should there be a medical emergency, right? This is us. And so the way that it's more or less written, although this is one of the areas that I think need to be tightened up, is that there would be a form that would be developed like with our Department of Health, or like what would be the basics we would need to know about folks. It would be distributed to the people on board. They would have an opportunity to refuse to answer the question. So they're voluntarily choosing to share the information should there be a medical emergency. The plane, so whether that's the charter plane or Coast Guard or the FBI or the state police, they are the holders of that record, but because it's actually voluntarily provided, the details of how that's going to be used is provided to the person who's completing that form. So they're not, providing information that they know that could get used in a way other than what they understand it to be used. So then it gets held by the plane. So the job of the FBO before they service that plane is to make sure that that is on board. They don't collect it. The only time it transfers hands, and this would all be on the form that the person's filling out voluntarily, is should there be a medical emergency, should emergency responders respond to that plane, the forms for the individual who's having the medical emergency would be transferred to the emergency responders and then ultimately to the hospital or wherever they get transferred to.
But how would you guarantee compliance that it's actually occurring without, say, the MAA or someone else looking at these documents to see that someone is actually gathering this information? How do you guarantee that compliance, that these forms are being filled out, or someone would have to review those, right, to see that that's happening?
It's a certification that would happen between the FAA and whoever's flying the flight, certifying that those forms are on board. So the MAA is not collecting forms. The FBO is certifying with the operator of the flight that those forms have been collected. and that operator of the flight is signing off saying those forms have been collected and are on board that flight.
Okay, so we're back to the FAA here, which is a federal agency.
No.
And
Did I say the FAA?
You said
I said
FAA.
the FBO. Oh, sorry, I meant to say the FBO. Sorry.
Okay.
The flight fixed-based operator is engaging with the operator of the flight, whether that's an airline, the Coast Guard, an FBI flight, whoever it might be. And there is a certification of that person responsible for that flight is certifying that they have those forms on board and that they are complete, and they're signing a document with the fixed-based operator that they have those forms on board. So we don't see it. No one in Maryland sees it, the fixed-based operator, the MEA, no one sees the forms. We create the forms and give it to the flight, but nobody reads the information about the health information, unless there's a medical emergency. And the form itself, which is voluntary to complete, indicates that on the form. This is going to be under the custody of whoever's flying the flight, unless there's a medical emergency, in which case we transfer the custody of this document to the EMTs who come, or the hospital, or whoever it is. And the person is signing, saying they understand that. In the same way you could sign your HIPAA rights away. Like if you're signing the document saying you understand what's happening with your medical information, you can do anything you want with that. We still don't want the stuff shared widely, but that's the structure of it. And I do think there's a couple of elements of that section of the bill that didn't get written the way I had intended. So there may be some tightening up, and if you have some specific ideas on that, I'm happy to entertain them.
Thank you.
Okay, do not see any further questions. We do have a virtual favorable amendment witness, Robert Cornett, Frederick County ICE BWI Coalition.
Chairman Corman, Chair Guyton, and members of the committee, thank you for the opportunity to testify. My name is Robert Cornett from Frederick, and I organize with community and faith partners concerned about the treatment of people detained and transported on enforcement flights that use Maryland airports. I support House Bill 639 and urge a favorable report with clarifying amendments. This bill addresses a narrow but serious problem. People shackled on enforcement flights may have significant medical needs or active legal matters. If there's no clear process to identify those needs or ensure they are communicated before someone is kept on board during fueling or moved on a long-distance flight. HB 639 sets out basic protections so people are not exposed to unnecessary health and safety risks in Maryland's air transport system. This bill is about what Maryland regulated actors do on the ground. It does not tell the federal government whom to detain or remove or how to operate aircraft. It sets expectations for airport contractors and health and legal professionals, areas within Maryland's traditional authority over health, safety, and professional regulation. I do, though, urge you to make two clarifications. First, make explicit that these protections apply at any public use airport in Maryland, whether owned by the state, a county, or a municipality, so they cannot be sidestepped by shifting enforcement flights elsewhere. Second, clarify that the forms are voluntary, they're handled by designated groundside or health personnel, and treated as confidential information held by a designated state-regulated entity. With these clarifications, HB 639 offers a practical framework to protect people's health and safety on enforcement flights, and I respectfully ask for your favorable report. Thank you.
Thank you. Seeing no questions, that concludes the bill hearing on House Bill 639. We'll turn to House Bill 510, Delegate Cardin, Motor Vehicles, Automated Speed Enforcement, and Proper Registration. Please go ahead when you're ready.
Thank you, Mr. Chairman, members of the committee. John Cardin on behalf of House Bill 510, asking for a favorable report. As I mentioned when I was here, I think last week, I had two bills with you this year. This is number two. And I think this is a really important bill. It is a supplement to another bill that I think you either have already heard or you're going to hear, dealing with Virginia registration, Virginia license tags. I think it was Delegate Addison's maybe. This is a bill that You will note, I'm trying to keep everything as expeditious as possible. There's a number of people that I believe have testified in favor of the bill in written testimony only. The MVA is available for information purposes. I don't know if they're here, but they told me that they would be happy to answer any questions if you guys had any, and that they want to support the bill. There may need to be some technical amendments if the committee chooses to move forward. As you know, the problem that we have is that current enforcement mechanisms are ineffective when drivers intentionally register vehicles with out-of-state tags and therefore avoid accountability. When vehicles with Maryland plates go through speed cameras, they get tickets, they have to pay them. If they don't, they get additional fines, et cetera. We had that debate, I believe, this morning on the floor. With speed cameras. However, they avoid that if they do not have Maryland tags, or specifically if they have Virginia tags. Given the change in administration in Virginia, I think that Virginia would be very open to reciprocity with us. It's something that has to happen for this bill to work. And basically, if you look at any kind of with total impunity, and they can go as fast as they want, it's just unsafe for us. It's unsafe for everybody. It also avoids certain fines, fees, and insurance requirements that we have here in Maryland, as you guys are much more familiar than I am. In Baltimore City alone, there were 14 fatalities and over 7,000 non-fatal crashes with non-Maryland, specifically Virginia tags, just in Baltimore City. So imagine how much safer our roads across the state would be if we do this. I'd be happy to go into more details about what the bill does if you want.
We have a question from Delegate Lewis.
Thank you, Mr. Chair, and thank you, Delegate Cardin, for bringing this bill. Actually, my questions have been answered.
Okay.
Thank you, Mr. Chair.
Any additional questions on the bill?
Good.
Okay, thanks very much, Delegate. That concludes Bill House Bill 510. We'll turn to House Bill 601. Chair Polakovich-Carr on behalf of the Montgomery County Delegation. Stop Sign Monitoring Systems Pilot Program, Gaithersburg and Rockville.
Thank you, Mr. Chair. And I have a witness who's going to join me too. Good afternoon. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 601 on behalf of the Montgomery County House Delegation. This bill would allow 2 municipalities in my district, the cities of Rockville and Gaithersburg, to opt into the existing pilot program for stop sign cameras in school zones. The goal of the pilot program is to make streets near schools safer for pedestrians, including students who walk to school. As this committee knows well, in 2024, the General Assembly authorized Prince George's County and its municipalities to deploy cameras at intersections in school zones. And last year, legislation was enacted to expand the pilot to include Tacoma Park and parts of the city of Baltimore. The initial data on the efficacy of these cameras is very promising, with several municipalities in Prince George's County reporting significant declines in violations since the deployment of the cameras nearly a year ago. I'd like to bring these same safety benefits to my district. 1 in 5 Montgomery County public school students walk to school, my family, my son included. This bill isn't just about protecting students. In my district, there were 2 residents who were tragically killed in 2022 while walking home from voting at Fields Road Elementary School. They were in a crosswalk at an intersection near the school when they were struck and killed by a driver who did not stop at the stop sign. Both cities, Rockville and Gaithersburg, are in full support of the bill, and it passed the Montgomery County House Delegation unanimously. Thank you for your consideration.
Good afternoon, Rockville's own Chair Corman and members of the House Environment and Transportation Committee. I am Rockville City Council member Marissa Valeri, and I thank you for the opportunity to share the City of Rockville's strong support for HB 601. The Mayor and Council thank Delegates Polakovich-Carr, Spiegel, and Vogel for sponsoring this important legislation that we unanimously support. HB 601 aligns with Rockville's Vision Zero and Pedestrian Master Plan. We believe the bill is a much needed tool to help our children travel safely to and from school. And like the delegate, my son is a walker to and from his high school, and he sees this on a daily basis. In Rockville, we have multiple schools within our borders, including 15 operated by Montgomery County Public Schools. One of the city's top traffic-related concerns received by the Rockville City Police is stop sign violations. Since January 2020, city police have directed patrols for stop sign violations. During this time, RCPD has issued 470 traffic citations and 4,695 warnings for stop sign violations. Further, they have handled 23 crash reports in which one or more of the contributing factors was failing to stop at a stop sign. Due to the extremely high volume of requests, it is very difficult for our officers to conduct enforcement when they are handling calls for service. We believe the use of this technology would be a police multiplier and incentivize change driver behavior, similar to what we experience with speed and red light enforcement systems. HB 601 is a major step forward. Keeping our children safe from drivers who are increasingly distracted and do not follow stop sign laws is essential. We urge the committee to provide HB 601 with a favorable report.
Awesome. Thank you for remembering your prodigal son from Rockville. Any questions for this panel? Okay, thank you. We do have in-person favorable testimony from John Seng, Maryland Coalition for Roadway Safety.
Thank you again, Chair Corman and members of the ENT Committee. Let me speak candidly. I'm frustrated. Our communities are frustrated. As you just heard, parents are frustrated. Too many drivers in Maryland simply blow through stop signs, and most problematically near schools. They roll through, we call it the California stop. You've all heard that before. Or they just drive right on through, treating the red octagonal stop sign as if it were an option. But first, before I go on, a little history. The stop sign, the red octagonal stop sign, is 112 years old. It was invented in Detroit in 1914 by police officer Harry Jackson, who noticed that vehicles weren't slowing down. So we were even innovating in the U.S. as early as 1914. Imagine that. So it only took 2 years before, a year later was adopted by the entire state of Michigan by 1922 throughout the entire USA. So here in 2016, people blow through these stop signs because they feel they can just get away with it. I want to say that, it's a big problem. I'm not going to recite any more numbers, but just another anecdote that I witnessed in the past month. I was on a tour with one of the companies, one of the technology innovation companies that installed these in Berwyn Heights, and I saw something I haven't seen in years. And it wasn't someone being caught or photographed or imaged by one of the stop sign technology devices up on the pole. The device was there. There were 3 signs warning drivers to stop at the red octagonal sign. I stood there for 15 minutes, about 20 yards away. Every single car rolled to a stop, 1,000, and then proceeded. They knew it was there. They knew about enforcement, and it works. So that's my own data for you. Safe Roads Maryland strongly encourages you to take up a favorable report for HB 601. Thank you for your leadership in road safety.
Thank you very much. I do not see any questions. That concludes the bill here on House Bill 601. We'll turn to House Bill 669, Delegate Pruski, Political Subdivisions, Third-Party Road Improvements, Satisfactory Completion. If you have a panel, please bring them up.
Yes, sir. Thank you. Thank you, Mr. Chairman, Madam Vice Chair, and members of the committee. I am here, for the record, Delegate Andrew Pruski, presenting on HB 669, Political Subdivisions, Third-Party Improvements, Satisfactory Completion. The bill in front of you prohibits a political subdivision for issuing a use and occupancy permit to certain entities holding a permit to complete certain improvements on certain state roads until the improvement's completed to the satisfaction of the State Highway Administration and the political subdivision and generally relating to state road improvements. Anytime you go to a hearing, you're wondering, why are you bringing a bill? Well, let me paint you a picture. Imagine if you have the largest employer in the state of Maryland in your district. Imagine if you had major arterials that any road improvement would have a change. And imagine you get emails from Prince George's County, Baltimore City, Baltimore County, Queen Anne's County to your district saying what is happening. Well, ladies and gentlemen, it happened in my district. Route 3 North, we have a project when I was running for office in 2022, where it was a third-party road improvement. The question is, the northbound Route 3, the intersection, they're essentially closed for a left turn off of St. Stephen's and certainly heading northbound. 70,000 cars a day. I just want you to think about that. So that's why you're getting emails from constituents who traverse to our largest employer in the state of Maryland, in and out, commuters, local, other things that occur. And it created constant heartburn. I continue to get emails to this day. So if you travel on I-97, 175, 3250, you're probably going to touch Route 3 at some point. Well, working with State Highway, we obviously found some background on why this project was delayed, and I do appreciate their support. They've worked with me along the way. Certainly there are legal and contractual issues that came up. But in summary, what is the intent? What do we need to do? Well, with 70,000 cars a day, if there's an interruption, and a project has lasted 4 years, the question comes, how do we fix it? What happened? Well, when we have third-party improvements, you need to make sure that these improvements get done in a timely manner, and there has to be accountability. In order to come to a solution, I work with the Maryland Department of Transportation, Maryland State Highway Administration, and that is the product being presented here today. In summary, this bill adds clarifying language to statute and stops a political subdivision from issuing a use and occupancy permit to a non-government holder permit authorized under the section. The bill only applies to state highways. It is not local roads, it is not county roads, it is state roads that have more than 25,000 vehicles a day. The use and occupancy permit can only be issued if the road work is completed or required under by SHA satisfaction or the political subdivision. I've had many conversations with stakeholders. I've certainly gotten feedback. I'm willing to work with anyone, but I have to say, inaction is not the answer. I would not like to happen this in your district, and I would hope that you would consider working with me for this piece, and we do have State Highway here today. I thank you for your time, consideration. I'm requesting a favorable report on HB 669. Thank you.
Good afternoon, Chair Corman, Vice Chair Guyton, and members of the committee. For the record, I'm Will Pines, Maryland State Highway Administrator, and I want to thank Delegate Pruski for sponsoring this bill. The Maryland Department of Transportation is serious about safety on our transportation system, and we also appreciate the governor's leadership on timely economic development and delivery through his recent housing executive order, and are grateful for the partnership we fostered with industry and local jurisdictions by focusing on expeditious completion of developments and roadway improvements. House Bill 669, as written, is a common sense approach that prioritizes public safety and timely road improvements in a manner that's balanced with strengthening Maryland's economic development and our communities. To be clear, most developer mitigations on state highway system goes well, and we work constructively with developer contractors and engineers to timely complete the work. Unfortunately, when roadway improvements are not completed in a timely fashion, communities and elected leaders are frustrated by prolonged work zone roadway conditions, traffic delays, and safety concerns. In the worst of cases, SHA must pursue relief through lengthy negotiations with the developer's surety and/or has stepped in to complete unfinished work. House Bill 669 would provide strengthening measures to advance Maryland's safety goals, minimize the duration of impacts to roadways, and protects taxpayer investments in transportation. The SHA also is aware of potential amendments being discussed related to the bill and will be happy to coordinate with the bill sponsor and stakeholders. Chair, Vice Chair, and committee members, I thank you for the time and request a favorable vote for House Bill 669.
Great, thank you very much. We have a question from Delegate Grammer.
Thank you, Mr. Chair. So I'm sympathetic to having a local road problem I'm trying to resolve, and I wanted to ask you, can you walk me through your problem and how this bill fixes that so I can understand more clearly what's going on?
Yeah, so first of all, the occupancy permit, my understanding of the building that's being built is already issued, still not fixed, right? So obviously it's there. I looked at, and again, respectfully to State Highway, do we look at maybe not allowing a grading permit, right? Fix the road first and do that. I was looking at the minimalist possible thing, and obviously this is what we came up with. I know there's been some amendments like, is it 25,000 cars? Is it 30,000 cars? Those are things being discussed, but ultimately, if you're getting that occupancy permit and that road, when it's not there, makes sense, right? Because you obviously want to have whatever's being done fixed. Now, there are some other amendments being discussed. As I said, this is just the introductory bill. So if people have other ideas to solve the issue, I'm open for them.
Appreciate it.
Thank you.
Delegate Lewis.
Thank you, Mr. Chair, and thank you, Delegate, for bringing this bill. Good to see you, Mr. Administrator. I'm curious whether SHA has had experience using its power through the contracting process to get private contractors to finish their work. I'm just wondering why legislation is needed when you have the force of legal contracts at, I believe, at your disposal. What's missing for you guys?
So we do require with the completion of developer projects a performance bond that's backed by a surety. Typically that is established for at least 100% of the estimated cost for a project. However, in the course of multiple developments, working through the volumes, the cases, examples where we've encountered issues. We found cases where the original surety estimate wasn't sufficient and the remaining work that was necessary to be completed was more expensive than the performance bond we had on hand. And so in those cases, sometimes the developer would just say, okay, State Highway, you go finish it because it's more expensive for us to do the work than to deal with the surety. Separately, just in the timing of whenever you have to pursue a performance bond and work with a surety, they have to go through the procurement process and bring on their own contractor. That contractor's unfamiliar with the job and has to be brought up to speed. So there's lost time, and throughout the duration of that lost time, the public is impacted from the work zone conditions that are there. So this is really about incentivizing developer community to make sure that the work is completed in tandem with the actual building or development improvements. We've had cases, an example recently, Raising Cane. Hopefully you've had lunch today. They got great chicken, go visit them. They had a Raising Cane that opened before the roadway improvements were completed, and we had an enormous number of complaints from the community and elected officials, traffic backing up onto the roadway, incomplete pedestrian improvements, things like that where, yes, we can pursue with a surety and have the work done, but this is just another measure, belt and suspender, to make sure that it's done timely.
Thank you. And just a quick follow-up. And I can only imagine the complexity of organizing, massive infrastructure work. And I know you guys do that routinely and you're the experts, and thank goodness. I just wanted to press a little bit further when I'm thinking about the complexity of these huge projects that are needed, that you guys lead. You have visibility into the industry and you know how certain vendors may perform. Is there just a sense that there's some vendors that are really high performing and deliver within the proposed agreement and others that don't? Is there some other way that this legislation might be able to help you guys avoid, some decisions that end up with poor performers?
So, and again, I do want to emphasize, most developers are great. The vast majority of the work that happens on our system goes well. Last year, we processed nearly 1,500 access permits in total. The TIS is all the development that has to happen statewide. Very few cases end up as bad as what we're talking about here today. To clarify the relationship, developer projects, our access permit is with the developer. Typically, they hire their own engineer and their own contractor, and the contractual relationship with their contractor is direct with the developer. We have no contractual relationship direct to their contractor. We don't do the procurement for them. We only step in and leverage the surety against the developer when that's necessary.
Got it. Okay, that's very helpful. Thank you. Thank you, Mr. Chair.
Delegate Healy.
Thank you very much, Mr. Chair, and thank you for the bill. I understand how complicated this is, but also, in my experience of watching these kind of things, when government interacts with private enterprise, the government is always at a disadvantage because private enterprise have the real expertise in their business. And sometimes, so my question is, when you're writing these contracts, do you have the ability to go out and find the kind of people who can advise you to write contracts so that you don't end up in a situation where the surety is woefully short of what is necessary in case that somebody defaults? I mean, we saw this over and over again with the Purple Line, but I've seen it in many other industries as well. And oftentimes, if there had been enough attention given at the beginning of the process, you wouldn't be holding the bag at the end, and especially if the surety is not big enough. So my question to you is, what are you doing to take care of it at the front end of this process so that you do have the expertise that you can't possibly have dealing with somebody who that's their only business?
Sure. So I do want to clarify again that in terms of the contractual relationship for this case, we don't write a contract, we simply have an access permit. State Highway's role in the access permit process is not to deny developments. That is done at the local jurisdiction level through the planning and zoning process. Okay. The developers typically seek a site development plan approval with the county or the local jurisdiction. When they receive that approval, then they engage with us for the actual connection into the roadway. Our role is simply to make sure that the traffic and pedestrian trip generation, those other things that are generated by the developer's new installation, are effectively mitigated and that road improvements are done as necessary to deal with that, the impacts of that development. So frankly, our access permit with a developer is pretty short and straightforward. Okay. They develop a cost estimate for the project up front. We do a cost comparison against what we call the category code manual to verify that the surety amount seems reasonable. But sometimes when they actually hire their contractor, the costs come in higher than what the estimate was. And when that happens, we already have a surety in hand before they even have the contractor in place.
Okay, I appreciate that very much. And you do a great job. There's been great developments in my district where they would not have happened if State Highway had not worked well with the local government and with the developer. So I'm just looking for a way to help things along the way. Thank you.
Thank you.
Okay, I do not see any further questions. We do have some favorable amendment in-person testimony, like old times. Bob Enton, Maryland Building Industry Association, and Tom Ballantyne, NAIOP, Maryland.
Mr. Chairman, with your permission, I'll go first. Tom Ballantyne with NAIOP, Maryland. We're a commercial real estate trade association here to support House Bill 669 with amendments. We understand the bill arises from a situation where the failure to complete road improvements contribute to long-term traffic safety concerns and congestion. And recognizing the seriousness of the circumstances and the need to make sure it doesn't happen again, we're favorable with amendments. We've met with the bill sponsor and are pretty much in fact-finding mode at this point, to be honest. But the highway access permit is one of the most difficult to manage state permits, and putting the access permit in the critical path of a use and occupancy permit raises major concerns for us. There are numerous valid scenarios that are agreed by SHA, such as phasing of infrastructure for large projects, where a use and occupancy permit is issued prior to the closeout of the highway access permit. Improvements are sometimes put in service once they're substantially complete, even if the administrative closeout or maintenance period remains to be completed. The first question our members asked was, why didn't SHA pull the bond and complete the improvements? We believe the reason for that needs to be understood so that a solution can be put in place, whether it be higher bond limits or letters of credit. The bill also requires local approval of the state road improvements. That's a joint approval process that would be new and is undefined. So we believe that there needs to be more work done here to find a targeted solution that addresses the specific breakdown that occurred without creating new implementation problems for third parties who comply fully with their SHA obligations. Thank you for the opportunity to speak today.
Thank you. Mr. Chairman, members of the committee, Robert Enton on behalf of the Maryland Building Industry Association. We are signed up favorable with amendments. We participated in the meeting yesterday with the sponsor. We understand what happened in the sponsor's district. We want to work with the sponsor and with SHA to come up with a way to address this issue which doesn't slow down dramatically the ability of people to occupy these housing developments. Housing is, all we hear all year long is that, housing is a top priority of the Maryland General Assembly and of the governor this year. And what we don't want to do is see something pass which makes housing less available than it is today. We're going to work with the sponsor and SHA to come up with a reasonable way to address the issues that were raised. Thank you.
Thank you. I do not see any questions. That concludes the bill hearing on House Bill 669. We'll turn to House Bill 726. Delegate Bob Long, Maryland Transportation Authority, Francis Scott Key Memorial Bridge naming.
These chairs and me do not get along. Try this again. I think he needs some new chairs down in another committee. This thing's not going to roll. It's probably the operator. Let me get myself straightened out here. Thank you, Chair, Vice Chair, and esteemed members of this committee, and even my friend over there. Payback. It's a very simple bill. It's to name Francis Scott Key Bridge to make it sure that it remains Francis Scott Key Bridge. If you look, I did do an amendment to remove memorial. And what I want to do, what this is about is codifying the name, not only for the history behind the Key Bridge, but also the different contracts and stuff. We have to be able to identify, the Key Bridge. Right now, it's not codified. It's never been dedicated. So I don't know how the state actually identifies it. So that's what this bill would do. We want to make sure that we don't receive no hiccups when they start rebuilding the bridge. And it's a very simple bill. Key Bridge, Francis Scott Key Bridge is a Francis Scott Key Bridge. I don't know if anyone here is a boater or not, but they actually put a buoy out each year where he was supposed to be sitting when he wrote the Star Spangled Banner, when he was held prisoner on a ship. That's why it was named Francis Scott Key Bridge. And I would ask for a favorable vote on this. It's very near and dear to my heart and the people in my district. And again, we just want to make sure that the name is, there's not going to be no confusion once we start getting under the construction phases. I think they're getting ready to, it's called notice to proceed here shortly. So that's why I brought this bill. Thank you.
Thank you. Any questions for the sponsor? All right, that concludes the bill hearing on House Bill 726. We'll turn to House Bill 777. Delegate Spiegel, Motor Vehicles, Hot Cars Act. If you have a panel, please bring them up.
Now it rolls. Watch your chair. Yes, sir. See it.
Thank you, Mr. Chair. For the record, I think the chair is fine. We also, I believe we have one virtual witness who's part of our panel. I just wanted to note that. Good afternoon, Chair Corman, Vice Chair Guyton, members of the committee. For the record, Delegate Ryan Spiegel on behalf of House Bill 777. And while I do always try to break the ice with my bill hearings with a little joke at the beginning, the truth is this is an issue that is very, very serious and, in fact, deadly. This bill, put simply, requires new passenger vehicles manufactured after a certain date to have what's called a rear occupant alert system. And I introduced this bill in the wake of a tragic incident in my community last year where an infant was inadvertently left in the rear seat of a vehicle and died of overheating. And it was not intentional. It was a momentary failure of human memory with irreversible consequences. And it can happen to anyone. Extensive scientific testing has shown the shocking speed with which vehicle cabin temperatures can rise dozens of degrees in mere minutes, even when the outdoor temperature is mild. And you see that we have here some demonstratives showing real-world temperature tests and the difference between the temperature within the cabin and outdoors. The danger to infants, to other vulnerable passengers, and also to pets is grave. Nationwide, on average, roughly 35 to 40 children die each year after being left in hot cars. And since tracking began in the late 1990s, more than 1,000 children in the United States have died in these entirely preventable incidents. This is precisely the kind of human error that technology can prevent. Now, to their credit, most major auto manufacturers already voluntarily include what's called an end-of-trip reminder system in many or all of their new models. And some of the members of this committee may even have newer vehicles with this feature that reminds you to check the back seat when you turn off the car. And I commend the industry's investment in these systems to improve safety. But to me, the fact that so many manufacturers are already doing this is, in my opinion, further argument for, not against, this bill, because it demonstrates that the technology is widely available and it's inexpensive. These systems are simple. They don't require cameras or sensors. Usually, they work by detecting that a rear door was opened before a trip, and they display a sound or a reminder to check the back seat when the engine is turned off at the end of the trip. The estimated cost of this feature is under $20 per vehicle, which is a negligible amount in the cost of a new car, and one that's already absorbed, as I mentioned, by much of the industry. HB 777 doesn't mandate a specific version of that technology, and manufacturers can use audible alerts or dashboard messages or any comparable reminder system. It applies only to new passenger vehicles and doesn't apply to used vehicles already on the road. For years, the National Highway Traffic Safety Administration has been studying, or says it's been studying, regulatory options for rear occupant reminders. And federal rulemaking on these types of systems was anticipated, but it has been stalled out for years. Under federal law, NHTSA was supposed to issue a rule back in 2023 and has yet to even publish a proposed rule at this point. So in the absence of federal action, states can and should look at narrowly tailored, low-burden safety standards. And I want to point out there was an error in the original draft of the bill, and we have a sponsor amendment before you clarifying that the requirement isn't contingent on NHTSA issuing their final rule. Waiting for the final federal rule before the safety system requirement is implemented would defeat the whole purpose of the state bill. Additionally, in response to concerns raised by the Maryland Motor Truck Association, a second provision of our sponsor amendment clarifies that the requirement only applies to vehicles weighing less than 10,000 pounds of gross vehicle weight, which is pretty much every standard passenger vehicle on the road. It's not intended for large cargo trucks and such. In developing the legislation, I spoke with representatives of several major vehicle manufacturers. And again, I appreciate the voluntary commitment to addressing this important safety concern. But while many have implemented this technology, the fact is it's not all manufacturers and it's not all models. And for those who have already implemented it, a state requirement shouldn't be an issue. They're already doing it. For those who haven't, this legislation will ensure that they do it in reasonable time. And it gives manufacturers multiple model years of runway to comply, to reduce the obstacles to compliance, and to recognize the multi-year development process for new model vehicles. This bill is also intentionally modest. It's not a perfect solution. It won't prevent every tragedy, but it will prevent some, and at minimal cost, using technology that already exists and is already widely deployed. So it's a good first step. And for those manufacturers who want to innovate, pursue more effective and more involved rear occupant safety systems, I certainly welcome and encourage that. But this bill creates a floor, not a ceiling. I also want to note the bill is formally supported by the Maryland Legislative Black Caucus, the Women's Caucus, and also by the Maryland Automobile Dealers Association, who is here on our panel, and it has a fiscal note of 0. Now, I want to address what I anticipate will be industry concerns. The industry has raised concern about state-level regulation of vehicle safety requirements, arguing that the federal government is the only appropriate level of government to implement these types of requirements. But I want to point out that state regulation on this sort of thing is hardly unprecedented. The reality is that we already have a number of requirements in state law in our transportation code for things like seatbelts, headlights, certain types of brakes that need to be in vehicles, just to name a few. It's also well known, of course, that California has promulgated several state laws regulating the manufacture of vehicles as well. And yes, California has a much larger share of the national market for vehicles, but the point is we have the legal authority and the ability to do this at the state level. And I will add that California and New York are already also starting to consider similar state legislation on these types of systems. And the need for this bill arises precisely because the federal government has not acted on its responsibility to address this deadly issue by failing to meet mandated deadlines and by slow walking it for years. Maryland's vehicle market may be smaller than New York's and California's, but we have an opportunity to lead here, and I would argue a moral duty. This is a straightforward approach with a minimal cost burden, and it will save the lives of infants. So I respectfully request a favorable report on House Bill 777. Thank you.
Good afternoon, Chair Corman and members of ENT Committee. My name's John Seng. I chair and have founded Safe Roads Maryland, and we rise in strong support of House Bill 777, the Hot Cars Act of 2026, introduced by Mr. Spiegel. This bill is about something no parent or grandparent, speaking of yours truly, believes could ever happen to them until it does. A child falls asleep in the back seat, your routine changes, a text comes in out of the blue, stress intervenes, we all get overloaded, and we fail our family. We fail that child left behind in the rear seat. Not out of neglect, not out of indifference or uncaring, but out of human fallibility. In a closed vehicle on a mild spring day, as you've seen in these charts behind us, or a blazing summer afternoon, temperatures can climb with terrifying speed. Within minutes, a child can suffer irreversible stroke. In Maryland last year, as Mr. Spiegel shared, we lost children this way, including the 2-year-old in Montgomery County, but also a 6-month-old in Harford County. Those families will never recover from those days. We appreciate that HB 777 does not criminalize parents, instead recognizing human vulnerability. And so what we want to do is get this technology in all vehicles that are sold as new, a prompt, a pause. It's working in my own vehicle. I don't take children around that much, but what it's done is trained me to second guess myself. Whatever vehicle I'm in, whether this technology is in it or not, now I'm conditioned to think because I'm getting this visual reminder as frequently as I do. HB 777 is a modest requirement with profound impact. Safe Roads Maryland respectfully urges your favorable report on HB 777. Thank you.
Mr. Chairman, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. We represent 300 franchise new car truck dealers and their 20,000 employees across the state of Maryland here in support of House Bill 777. I had the opportunity to meet with Delegate Spiegel last week. We greatly appreciate this bill bringing a spotlight to this issue, and we don't need to go into any more about how critical an issue it is. It absolutely is. I wanted to take this opportunity to highlight the technology. Many of you have bought a car in the last 5 or 6 years. vehicles have a lot more safety technology on it, lane departure, some of which people question, does it really help? It kind of gets annoying, if you get close, it vibrates. This technology is not that. This technology works. I commend the manufacturers. I looked up today to see what the trend has been, and starting in 2024, the number of models that have this technology is going straight up. We're at about, I think, 93%. But as Delegate Spiegel mentioned to me out in the hall, we need to be at 100%. And we agree that, now look, there are going to be some vehicles that don't have a back seat, so that this necessarily wouldn't apply. But we want to see as quickly as we can to get 100% of the vehicles, and we want to highlight this technology as being available. I don't think a lot of people are aware that this is out there. And again, most people, as has been said before, think, well, this would never happen to me. Well, I certainly pray that it never happens to anybody, but this is something that works. It addresses a very critical problem, and we would ask for a favorable report.
Thank you. We'll bring up our virtual favorable witness, Juan Carlos Perro from National Safety Council.
Good afternoon, Chairman. Madam Vice Chair, members of the committee. For the record, my name is Juan Carlos Perro, and I serve as the State Government Affairs Manager for the National Safety Council. The National Safety Council has been America's leading nonprofit safety advocate for more than 110 years. Our mission is to eliminate preventable deaths and injuries on our roads, in our workplaces, and in our communities. We represent over 13,000 member organizations and nearly 41,000 work sites nationwide, including 358 in Maryland. Our work is grounded in data, evidence-based solutions, and a commitment to making sure that every family gets to stay whole. We are honored to testify today in strong support of House Bill 777, the Hot Cars Act. When people hear about children dying in cars, they often think about states with extreme heat, but the data tells a different story. Maryland has experienced repeated tragedies over the past several decades. Since 1998, 16 Maryland children have died in hot cars. 2 of those deaths occurred recently, as the delegate had mentioned, in Montgomery County and in Harford County. Each one of these incidents represents an unimaginable loss for a family and a trauma that ripples across an entire community. Even on mild days, the interior of a car can climb to deadly levels within minutes. These risks are not hypothetical, and it's been consistently and presently deadly, nationwide. Nationally, these numbers are equally sobering. In 2024, 39 children lost their lives in a hot car. That's a 35% increase from the year prior. And over the last 25 years, over 1,000 children have lost their lives across the country. Over half of these cases involve children who were unintentionally forgotten. These are not cases of malice behavior. These are breakdowns in memories and routine. A technology that is just a reminder about and not assigning blame. It's about adding a layer of protection where the human memory can fit. This bill requires, as the sponsor had mentioned, newly manufactured and newly assembled vehicles sold or registered in the state to include rear occupant alert systems, and we also support the amendments presented by Delegate Spiegel. These systems provide a reminder to check the back seat when the vehicle is turned off, and many automakers, as previously presented, have made this part of their technology.
Great. Thank you so much. We really appreciate your testimony. Your time expired, but we appreciate you being here.
Thank you, Chairman.
We have a question from Delegate Lewis.
Thank you, Mr. Chair. Thanks so much to the good delegate for bringing this bill. Thanks to your panelists. I couldn't picture what this technology looks like. I'm car free, and the last car I owned was like a 2006 Subaru. So I went online to look at it, and it really is just a sort of a reminder on your dashboard, like your check engine light, that just says check rear seat. So that does seem, as you say, Delegate, that seems pretty simple technology. Are you aware of manufacturers that are actively opposed to making this seemingly simple upgrade available in Maryland? And what would their objections be, and what would that look like?
Thank you for the question, Delegate. My understanding of these systems is the same as yours. There are also more advanced systems that are being pursued out there as well that involve sensors and cameras and other types of features, which again, I commend certain manufacturers who are pursuing those more advanced technologies for doing. I will let the industry speak for themselves. But again, in my conversations with them, I will say generally they have not objected to the idea that we should have this technology. And in fact, so many of them are already doing it voluntarily, which again, I commend. I think there is a philosophical objection to the idea that states shouldn't be regulating the manufacture of cars. That's what I heard. But again, I don't want to put words in the mouths of the manufacturers. I'll let them present what they consider to be their arguments. So.
Great, thank you for that. Thank you, Mr. Chair.
Any further questions? Okay, we do have unfavorable in-person testimony from Joshua Fisher, Alliance for Automotive Innovation.
Thank you.
Good afternoon, Chair Corman, Vice Chair Guyton, members of the committee. My name is Josh Fisher. I'm with the Alliance for Automotive Innovation. We are the trade group representing the automakers that produce the most vehicles sold in the U.S. each year. And yes, while I am here to request an unfavorable report, it's not because we disagree with Delegate Spiegel's goal. The industry shares his goal. We deeply respect Delegate Spiegel's intentions. However, this legislation is unnecessary from our perspective because of the voluntary commitments he's made, noted, and pending federal action. It is a tragedy when any child dies after being unintentionally left behind in a vehicle, and that's why automakers didn't wait for a mandate. We acted 7 years ago. In 2019, leading manufacturers made a proactive voluntary commitment to install this technology as standard equipment. The commitment is enforceable by the Federal Trade Commission, and it requires a combination of audible and visual cues to remind a caregiver to check the back seat. This isn't a future goal, it's happening right now. As of our October 2024 report, more than 260 vehicle models already include these systems as standard equipment. So what is happening federally? Yes, NHTSA is a little behind with their rulemaking. They were supposed to release it in December, but 6-week delay, hopefully it comes out soon. And I do want to mention that there are aftermarket products available right now for consumers. The used car market is twice as big as the new vehicle market in America. So if we really wanted to make this ubiquitous, used vehicles would also be required to have some sort of aftermarket functionality like new vehicles do. And yes, it is very important to note that federal motor vehicle safety standards are set at the federal level. If New York passed a bill on this, I guarantee you it would be different from Maryland and any other state. It's going to be different, and we're not making cars for individual states. So that is our philosophical objection to safety standards like this being implemented at the state level. So I request an unfavorable report. Thank you.
Thank you. We have a question from Delegate Foley.
Thank you, Mr. Chair. Yes. Thank you, sir, and to the automobile manufacturers for many of them volunteering to do this. That's great. But I did not see in your testimony that 100% of the manufacturers had guaranteed to do this or are doing this. So there are some manufacturers who are not doing it, correct?
Well, we don't represent every automobile manufacturer. We don't represent Tesla, Rivian, or Lucid. But our members have committed to do it, yes.
But are there manufacturers who are not doing it? Are there models?
Well, there's a two-door vehicle doesn't have a back seat, so it wouldn't make sense to put a reminder in it.
Okay, are you aware of any manufacturers or models that have a back seat where it isn't being done?
Yeah, it's not 100%, you're right, but it is ubiquitous. And again, there are aftermarket products available as well.
Yeah, I appreciate that, but it isn't 100%, so.
Well, then we're hopeful that there will be a NHTSA rulemaking in the future.
Okay, thank you.
Any additional questions? Okay, that concludes Bill hearing on House Bill 777. We'll turn to House Bill 763, a patient Delegate Conway, speed monitoring system citations failure to pay.
Good afternoon, Chair and Committee. I'm Delegate Conway here to introduce House Bill 763, Speed Monitoring Systems, Citations, and Failure to Pay. In reference to the bill on page 2, line 12, it talks about when the civil penalty should be paid. And sometimes things that should be paid are not paid in a timely manner. What I'm saying in this bill is very simple, which is reflected on page 2, line 23 of the bill, to take out, if you don't pay in a timely manner, that is not an admission of liability. And that's basically what the bill does. You can still have your registration suspended. You could still be refused to have the vehicle registered, but you won't be considered as being liable if you don't pay this on time. And with that, I would be glad to entertain any questions, and I would hope to get a favorable response for this bill.
Thank you. We have a question from Delegate Lewis.
Is a whole, well, let's say you lend your car to a friend and they get a citation. Are you liable? Let's say you lend your car to a family member. Let's say it's at the auto mechanics and they take your car for a test drive, which I've had that happen, and they get a citation. Are you liable for that? Or let's say a valet runs one of these stop signs or something, just going around the corner to park your vehicle. Are you liable for that? So if you missed the timeline on it, maybe checking it out to see, I wasn't in town when that happened, how did this happen? Then you're not necessarily liable for it. So the ticket does go to the car, but it doesn't necessarily go to you.
Does, thank you, if I may, does it, would this legislation, in the case where a parent lets their kid use the car?
Yes.
And the kid gets a ticket, and doesn't tell the parent?
No, gets a ticket in the mail. This is not necessarily, this is not the police giving you a ticket. This is a ticket that you run by one of the speed traps we talked about this morning.
Automated citation.
Yes, the speed trap automated citation.
Right. Okay, so the vehicle owner would get the ticket in the mail?
Yes.
Okay. Interesting. All right, thank you.
Well, you see, there's another thing too. Some insurance companies are tracking what you get. It depends, like you could have a no-fault accident, they can assign you points. You could get these tickets on your vehicle, it could show up on your DMV, and they could say, well, we have to raise your rate because of this, because of that.
Okay.
So there are other concerns in reference to, it seems like it's a small thing, but it can escalate very quickly.
Got it. Thank you so much. Thank you, Mr. Chair.
Delegate Foley.
Thank you, Mr. Chair. So I think I understand what you're trying to get at here, Delegate, but these automated enforcement mechanisms, they only record the license plate of the car, i.e. the owner, not the driver. That part we know is true. But if there is no admission of liability, then what's to prevent someone, whether they're driving the car or not, let's say they are driving the car.
Yes.
What's to prevent them from just continuing to rack up violations and not pay them?
That's easy. When it's time for them to renew their tags, they won't be able to renew the tags for the vehicle.
Okay, so you still would not be allowed to renew your tags?
No, you wouldn't be allowed to renew your tags.
What if the driver is from out of state?
The tags on the vehicle will not be able to be renewed. I mean, I'm not talking about, I don't know what we could do about Virginia tags, but if they're Maryland tags and someone from Virginia is driving your car, that the Maryland tags would be suspended.
But if they're Virginia tags?
I don't know about that.
All right.
I don't know that we can do
Okay, thank you.
Thank you.
Delegate Naraki.
Oh, thank you, Mr. Chair. Delegate, always good to see you, my friend. I'm over here, sir. Hey, how are you?
Okay, how are you doing?
I'm doing well, sir. So I'm always thinking about, saving folks a buck, basically, right? So I just want to make sure, I want to understand, does this have any impact on fines or any sort of late penalties or anything like that you might accrue? Look, I got 6 kids. You and I have had this conversation, man. I'm trying to live off of 20 pennies a day. I'm doing a diet right now about that. As a good,
you got the book.
It's a good book. It's a good book. So what does this do with that, Delegate?
All it just says is that the tickets have to be paid. If you don't pay the tickets, your tags will not be renewed. but I don't know that you were driving the vehicle, he was driving the vehicle. I know the vehicle was being driven and the fine is on the vehicle. And if you want to keep those tags valid, somebody's gonna have to pay that fine. That's just the bottom line.
Okay. Thank you for bringing the bill.
You're welcome.
Delegate Fisher Hidalgo.
Thank you, Mr. Chair. So in the case in which you were discussing with Delegate Foley, if someone chooses to sell their vehicle and not pay the fees or the fines, then how are the fines paid?
Well,
I mean, if you say it's basically
sure on
tags.
Yes, I understand what you're saying. As I understand it, you won't be able to transfer the tags or transfer the vehicle with motor vehicles until the fines are paid. It's called a flag. They put a flag on your vehicle, and basically nothing can be done.
A flag on the vehicle or a flag on the tags?
The flag on the tags is a flag on the vehicle, because the vehicle can't be transferred, as I understand.
Okay, we'll have to look into that. I'm not sure, because they just suspend the tags, but the vehicle has its own VIN number, and I think it's ascribed to the tags, not the vehicle, but I'll look into it.
Well, the tags are connected to the vehicle, right?
Not if they're expired, or if they just turn the tags in. Let's say they just sell the vehicle. They turn the tags in, the vehicle gets sold to somebody else in another state, or in the state of Maryland, or whatever.
So as I understand it, on a case where let's say, if I turn the tags in on my vehicle and there's still fees on that vehicle, then those fees get connected back to me.
Okay, thank you.
All right, any further questions? All right, thank you very much. That concludes the bill here on House Bill 763. We'll turn to House Bill 567, Delegate Jay Long, Motor Vehicle Laws, Registration Plates, Single Registration Plate. And if you have a panelist, feel free to bring them up.
No panel will touch this. Thank you, Mr. Chair, and my fellow members of the committee. Try not to roast me too bad. All right, listen. You have my written testimony. Here's what I'm aiming to do. Clearly, we need more money for our TTF. There are a myriad of projects we want to see funded and built. Calvert County, Thomas Johnson Bridge, we have projects all across the state of Maryland. In your opposition testimony that I'm going to go ahead and reference, you will see that there are folks who are concerned that if we eliminate the front license plate, that public safety will be affected. And then, of course, addressing the MVA testimony that there'd be a loss in revenue because they use specific transponders to read front license plates for the sake of tolls. But I want to lift up the fact that there are 22 states that do not require a front license plate. And 2 of those states are our neighboring jurisdictions, Delaware and Pennsylvania. Alabama, they have a prepaid toll system. All you have to do is slow down and allow the antenna to read your window tag in the unnamed toll lane. Alaska does not require a front license plate. Arizona, they have no tolls and no front license plate. Arkansas, no tolls, no front license plate. Delaware, they have a new user-friendly system. They've modernized the technology. And they now allow residents to receive a consolidated invoice per month containing all transactions for that toll period. And each reflects only the toll amount due. This is not about tolls, but I feel that the argument that we're seeing to oppose this bill is because of the potential loss in revenue in toll. It costs about $2.7 million to produce these front license plates every year. If we eliminate front license plates, we could add about $2.7 or $2.8 million to the TTF annually, which will add up and help support all the various needs that we have project-wise. And so I believe that it's great for conversation, and I think that if those who are in opposition would like to come to the table with some ways that we can strengthen and modernize how we read tolls in our toll system, and as well as public safety, we should have those conversations. But two of our neighboring jurisdictions that frequently pass through Maryland tolls only have a rear license plate. With that, I urge a favorable report. Thank you.
Thanks very much. Any questions for the sponsor, Delegate Fischer-Dago?
Thank you, Mr. Chair. Delegate, so I see in here the Maryland State Police is opposed. I've seen this bill, I don't know, 5, 6, 7, 6 times. And with that said, they continue to have the same concern when it comes to, I mean, there's a lot of concerns with tolling and blah, 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 but I want to narrow in on their concern, which is a criminal justice concern. If there's a hit and run accident or any other criminal activity and you see the vehicle leaving, then maybe you get a snapshot, maybe you write a tag number down or something like that. But in the case of not having a front tag, that makes it significantly more difficult depending on the way the vehicle is leaving or leaving the scene. So how do you address that? Because that seems to me to be, of all the years that I've heard a version of this bill, which is pretty much the same bill, like how do you address that issue? And I understand that other states are doing it, but you know, I don't know, that seems, that's a big sticking point to me because of, you know, criminal activity, even like a kidnapping or something. That could be the difference. Having a front tag or not could be the difference between saving somebody's life.
And Delegate, trust me, I do share your concerns, and I think that there are risks that we take in everything that we do as a deliberative body, right? And of course, I would never take something as public safety in a lighthearted fashion, and I don't want to throw the baby out with the bathwater either, right? I would encourage MSP to come to the table, as well as other local law enforcement agencies, and let's see and compare data, and let's compare trends to other states. What are the stats for crime in Pennsylvania? What has their mechanisms been to ensure that we aren't allowing folks in a hit and run incident to go free, but that we have things and mechanisms in place to help complement and ensure that if we went this route, we would not allow our law enforcement agencies to be out there blind on a wild goose chase, but still be able to be effective in their sworn duties. And so I really do believe that if this bill's been introduced over and over again, and there are states that are much larger than the 6 million Marylanders that we currently have residing here in this state. And crime stats, from what I roughly can throw at you, some states are lower in crime than we are in Maryland. Of course, we're doing a great job in that, but still, right, I just can't say that that is reason enough to say, no, we should not consider this, because other states have gotten it right in certain respects. And we may have certain jurisdictions in the state of Maryland, certain cities where crime may be higher than others, right? And I think we have to also examine it with a thorough lens. That's my perspective on it.
All right, I would just suggest that you continue to talk to them, because maybe there are new technologies coming around,
right?
You know, the bend, which would be great, because according to them, their LPR program, that 30 to 40% of all the tags are front tags involved in the criminal activity. They're grabbing them off of the front tag. 30 to 40% is a pretty big number, but I will leave it at that. Thank you very much. I would love to do nothing more than take the front tag off of my car, so I'm with you in spirit.
I understand.
Thank you.
Yes.
Delegate Foley.
Thank you, Mr. Chair. Delegate, are you aware that Pennsylvania is considering now requiring 2 license plates on the vehicles?
I was not aware, but thank you for that information,
Yeah,
Delegate.
there is a bill that is being introduced in the Pennsylvania Senate, and among the things that are cited, and this is what concerns me, are the automatic license plate reader, as you identified. The fact that Amber Alerts now, if a car is coming toward me, and there's an Amber Alert, there's no way for me to know if that is under the car's under the Amber Alert. And also hit and run and other accidents where witnesses may see the front of the car, but don't see the back of the car. So I just wondered if you had considered all of that, and that's not from the opposing testimony, that's just kind of from, looking on the internet quickly about what's going on in Pennsylvania. But those are some of the considerations that are under consideration in Pennsylvania, and I just wondered if you'd thought about any of those instances.
Well, thank you, Delegate, for your question. As I referenced to my good committee mate, I believe the answer would be also the same to you as it relates to the Amber Alerts and public safety. I understand that there is no catch-all when trying to go this approach, and I'm well aware of that, and I definitely have tried to take all that in consideration, and clearly the spirit of this bill is just to help us generate some more revenue for our TTF, all while still pushing our state agencies to evolve in technology. If we have AI in all these various forms, I find it impossible that we can't find a unique way to be able to save that $2.7 million annually, on top of finding a way to ensure that we can capture all the data needed. For example, we have speed stop sign cameras now, right? We are constantly evolving as relates to technology and automated speed enforcement. So why aren't we catching up in that same trajectory as relates to other public safety mechanisms? Are we still living in the dark age in that respect? And so I do believe that we need to keep this conversation going. I'm not aware about Pennsylvania, to answer your second question, but, they're in deliberations right now as we are. So thank you.
Okay, thank you.
Delegate Ziegler.
Thank you, Mr. Chair. Delegate, do you happen to know what the fine is for not having a front license plate in Maryland?
I would not know that offhand, but I can get that information for you.
That's okay. I was wondering because I see so many, in particular Teslas, driving around without a front license plate. And I'm also wondering, I don't know if it's a secondary offense or, but I wonder how much money we could raise by just fining people who aren't using the front license plate they should be using.
That's a whole separate conversation. I'm not one to like to take the charge on additional fines, but we can definitely talk about that offline.
Delegate Lewis.
Thank you, Mr. Chair, and thank you, Delegate Long, for being so thoughtful. But I'm a little confused. I think I heard you say that your bill would help save money so that the funds we have in our trust fund account, transportation trust fund account, could be used for things that we really want. But when I look at the fiscal note, it says that although state TTF expenditures would decrease significantly by around $2 million or so a year, starting in 2027, fiscal 27, state revenues would decrease by a lot more. So according to the Maryland Transportation Authority, the tolling authority, they said that just through the loss of tolls alone, because in the absence of a front tag, they alone would lose about $35 million in the first full fiscal year. So that's a lot more than the savings. So that feels a little bit uneven. And that's just the tolling authority. I guess it doesn't include loss of revenue from other types of violations, citations, and all that. I wonder if you could comment on that?
Yes, thank you, Delegate. I thought I did when I had opened in my opening statements that I was aware of their position that puts them at a loss. Again, I would love to find the data and work more with you offline. Let's see how many cars from Delaware or Pennsylvania with no front license plate pass through these toll readers, and they're able to capture those cars, right? What type of system is the MVA using? Could there be the potential to upgrade to ensure that there is no loss and that one capture of the rear or an antenna is enough, right? So that would be my pushback against that. Maybe they wouldn't lose 35 million if we found a way to do as one of our neighboring states again, which I have aforementioned, Delaware, updated to a user-friendly system just last year.
All right, thank you so much. Thank you, Mr. Chair.
Thank you.
Okay, do not see any further questions. We have additional favorable in-person testimony from Peter Kitzmiller from the dealers. And just to save time, let me also bring up the unfavorable testimony, Thomas Myers from AFSCME.
Mr. Chairman, members of the committee, my name is Peter Kitzmiller. I'm the president of the Maryland Automobile Dealers Association. I'm going to be very brief. We're here today in support of this legislation. And we had a very spirited legislative call on Monday, and I brought this issue up. Maryland's dealers and our customers have contributed the last two sessions significantly to the Transportation Trust Fund. And so we feel pretty strongly that a $2 million savings or $2 million plus savings is something we need to take a long, hard look at. I did see the fiscal note about the $30 million. I find it hard to believe that the state of Delaware and the state of Pennsylvania are foregoing $30, $40, $50 million a year in toll revenue because they have a single tag. I believe West Virginia also has a single tag. The other issue, and somebody mentioned it before, first of all, I think the fine for not having a front tag is $500, and mentioned that the fact that a lot of Teslas don't appear to have front tags. Most EVs do not have any openings in the front of the vehicle because there's no need to cool the engine like you do in a gasoline car. I drive an EV. I didn't even know I didn't have a front tag. I checked yesterday, I don't. I have a bracket in the back, but I didn't get a front tag. The only way to attach these tags at this point is to drill into people's bumpers. We have had a dramatic increase with customers specifically declining us putting on the front tag. And there's going to be another bill I think this committee is going to hear at some point in the next week or so. But there is a concern, especially with EVs, that there's not really an efficient way other than to drilling into your bumper to put these tags on. So with that, we would ask for a favorable report.
Thank you, Chair, Vice Chair, and members of this committee. I'm here in testimony in opposition of House Bill 567. I'm a member of AFSCME Local 1772, and I work as a MCE production supervisor out of Hagerstown. As you all may know, MCE is the who makes these tags for the state of Maryland. We run these shops with incarcerated individuals. And our tag shop's located right down here in Jessup. They employ roughly 60 to 70 individuals who rely on this every day to get up, go to work, kind of have a normal life being incarcerated. And MCE serves as an important structure, work environment for over 1,000 total incarcerated individuals. And we provide skills and training for the individuals that are behind the fence who look forward to getting out and having a structured life after being incarcerated. And this would hurt the shops, MCE, as the tag plant, because the revenue they would lose, along with the amount of individuals they would no longer employ. And also, you all hit on a lot of the things too, how in 2024, a study was done by the Maryland Department of Transportation Authority showing that over $35 million was recovered due to having a front license plate, which they would not have gotten due to the rear license plate. And also with AFSCME representing a lot of law enforcement, that is another opposition due to not having a front license plate. If the officer wasn't able to see the rear license plate, they would have no other way of notifying or noticing the vehicle that they were looking for. So thank you for allowing me to have testimony to opposition to this bill.
Great, thank you for being here. Any questions for these panelists? Okay, that concludes the bill here on House Bill 567. We'll turn to House Bill 646, Vice Chair Guyton, driver licensing, self-reporting of medical conditions.
Thank you, Mr. Chair, fabulous members of the Environment Transportation Committee. For the record, Delegate Michelle Guyton, District 42B in Baltimore County, and I come before you today with the first of two bills dealing with disabilities and driving, or actually disabilities and transit. First, I ask for your consideration of House Bill 646. This is super simple. It simply prioritizes the professional judgment of an applicant's personal treating physician in decisions by the MVA on whether to issue or cancel a driver's license when that person has self-disclosed a medical condition. So we heard a bill similar to this. It didn't have the exact same solution as this one last week from Delegate Kerr. He spoke about some of the trials and tribulations that folks with sleep apnea dealt with when they self-reported to the MVA. It is currently Maryland law that you must self-disclose a medical diagnosis that's been identified by the MVA as potentially hazardous for drivers. I am in agreement with that current law. However, I want to point out that the process for determination of a person's fitness to drive after they have made that self-disclosure, and again, these are people trying to actually conform to the law and not be on the wrong side of it. That process seems to be very inconsistent, as we heard last week, and also incredibly case dependent. And case dependent, in parentheses, comes directly from MDOT's testimony. It may also often include a re-examination through written or cognitive or driving test of a person who's self-disclosed. And some of this may require participation in a driver's education program if the MVA determines that they need to do that. Now, one of the other problems that we identified while researching this problem and this solution, which is purely to have a treating physician's note be the determining factor, the priority in these determinations, is also that when people did need to take those classes or practice their driving, if they didn't do well on those driver's tests, let's say maybe they hadn't done one in 50 years, it was very difficult sometimes for them to get that permit to be able to legally do so. So the second part of this bill requires that the MVA establish an expedited process for the learner's instructional permit for drivers whose licenses have been canceled and who need to access skill acquisition. That just makes sense. So for most Marylanders who don't live in Baltimore City and do get around by car or don't have the option for public transit, the ability to drive is really a necessary one for economic and community inclusion. And I think that's an important part of the conversation, particularly when we are talking about people with disabilities. The system for this determination, it should be consistent, it should be timely throughout the state, and it should rely on the professional opinion of the doctor who knows the person well and treats that individual for that problem, for that diagnosis. The MVA should be streamlining this process to get people safely is important, back onto the road, and this bill will help them achieve that goal. Now, there's one exception to this bill, and that is if law enforcement stops someone and refers them for re-examination because of the way that they were driving. Those people would not be exempt from all of the other testing that the MVA would like to do in this situation. And there's also one other provision that says, let's say the MVA is not comfortable for whatever reason with that treating physician's report. They do still have the option to require extra testing on a person, but they really need to primarily look at the treating physician's report before they do that. So that's the bill in a nutshell. I do have one other favorable testimony who is virtual, Donna Berry, who I believe is a constituent of the chair.
Yeah, thanks for working on this. Let's bring up Donna Berry, favorable virtual witness. Please go ahead.
Thank you very much. I wanted to share my experience.
the last time that I had to renew my driver's license. The questions had changed, and so I realized that I needed to answer honestly that I have a peripheral neuropathy, which affects my arms and my legs. I very much considered not being honest because I knew it could create complications. And I've since learned of many others who chose to lie for this very reason. So the MVA sent me paperwork for me and my doctor to complete. I don't remember the questions. My doctor said she had no concerns about my driving, but this wasn't good enough. The MVA decided I needed to complete the MATTERS exam, which is primarily a cognitive test. And per the person who administered it, it's usually required after a police referral. My peripheral neuropathy in no way impacts my cognitive capabilities. I was also required to take a driving test. The very first step is to back into a parking space, a maneuver I haven't done in over 50 years of driving. I failed, my license was immediately pulled, and I was provided no information on what happened next. After 2 weeks, I received a letter saying I could take the test again, but couldn't take a driving lesson because I didn't have a legal right to be on the road. Delegate Corman helped me. I got the permit on a Wednesday, took the lesson on Friday, passed the driving test the following Monday. 6 long weeks later, I had my license back. I've since learned that the MVA doesn't track the results of requiring this additional testing for self-reported issues. So there's no way of knowing whether any of this even makes our roads safer, which is something that we would all like to see. Thank you.
Thank you very much. Any questions for the sponsor or her panelist? Okay, that concludes the bill hearing on House Bill 646. We'll stick with the Vice Chair. House Bill 733, Maryland Transit Administration, Fixed Route Transit Services announcements.
Thank you so much, Mr. Chair. And again, the most wonderful committee that we have here. This is Mia Snyder. She is my policy director, and she's got some slides just to show you, demonstrate what we're talking about today. I'm asking for your favorable report on House Bill 733. This bill actually requires MTA and MARC trains to do what they're already supposed to be doing, right? Which is to provide real-time audible and text-based announcements for all stops and critical service information on fixed route transit. By ensuring that both clear audible announcements and reliable visual displays are available, this legislation will make Maryland's public transportation system more accessible to riders, particularly those who are blind, low vision, deaf, or hard of hearing. It also ensures that Maryland is in compliance with federal Americans with the Disabilities Act requirements. Under the ADA, fixed route transit providers must ensure that passengers with disabilities have equivalent access to information about stops and routes. I mean, I don't have to explain to you why this is important. You are going to hear from someone later who has difficulty, whose daughter has difficulty in these areas. But if you are a person who is hard of hearing and a visual display is not working to tell you where your stop is, it's very difficult for you to know where you are and how to get off. If you are a person who is visually impaired and there's not an audible announcement that you can hear, it is very difficult for you to navigate the transportation system. It is law, federal law, that they already do this. So, unfortunately, in fact, though, the announcements and the displays on these systems are inconsistent. Sometimes they're there, sometimes they aren't. Often they are broken. So this is where I'm going to pull up the slide for you to see. The person who brought this bill to me actually is a deaf and hard of hearing woman who does travel regularly by public transit. She has to work, and what we're showing you there, if you can see it, is the visual displays either not on. They're in and I think this is an important point, they're actually in these trains and on these buses, but they are not actively working. So you'll see that no service, some of them say, and then the others are blank. Out for service seems to be a very popular one as well. So it's really just not acceptable. So forcing riders with disabilities of different kinds to navigate using guesswork is not appropriate and it's not acceptable for this state, and it's actually not legal. And so I bring this bill to you requiring, in fact, that we have these accessible transportation options for people with disabilities on our public transit, fixed route public transit systems. Now, when I first started talking to the Maryland Department of Transportation, MTA, and Mark about this, they basically told us, yeah, we take care of this, we do this. So you can imagine how surprised I was to see an $8 million fiscal note so that they could take care of this and do this. I'm not sure where to go with that from right here. I can tell you that this is something that we are already supposed to be doing by federal law. We are not doing it. And at the very least, we need to find a way to push this forward so people with disabilities can get around safely on our public transit systems. So I am going to open it up now to, I believe I have one virtual, maybe two virtual testimonies.
Yeah, there are
That's
two.
all right with you, Mr. Chair.
Yeah, Ronza Othman from the National Federation of the Blind.
Good afternoon. Can you hear me okay?
We can hear you perfectly.
Excellent. Mr. Chair, Madam Vice Chair, of course, and members of the committee, my name is Ronza Othman, and I am the president of the National Federation of the Blind of Maryland. NFB of Maryland is the state's oldest and largest organization of and for blind, low vision, and deafblind individuals. We're very grateful to Delegate Guyton for bringing this legislation forward. We depend on public transportation to move about our communities, to go to school, to medical appointments, and so on. The story I'm about to share is one we experience quite frequently, all the time. I go to take a bus and I stand at a busy bus stop. A bus rolls up and I can't see the sign that says which bus it is or what route because I'm blind. If the audio announcements are turned on and working, I hear the bus number and route and I jump on my bus and go on my merry way to wherever I'm headed. But if the announcements are not on or not working or very low, which is quite often the case, I don't know if it's my bus, and more often than not, I have to ask strangers which bus it is. By the time I figure out if it's my bus, I've missed my chance to board it. Let's say I do board the bus, but I don't know where I am as we are approaching my stop because I'm blind. I can't identify where I am by visual cues, and thus I rely on the audio announcements. If I miss my stop, I'm then forced to get off at a different stop in a neighborhood unfamiliar to me, and I have to figure out where or how to get back to where I was supposed to get off. Sometimes a few unfamiliar blocks, sometimes a very scary, unfamiliar mile or more. Drivers turn down the announcements because they find them annoying, that's unacceptable, and a safety risk. When buses are inspected before starting their routes, a broken auditory announcement system is not considered major enough to keep that bus out of circulation or for expedited maintenance. This is beyond inconvenience, it's dangerous. For the reasons I shared here, as well as in my written testimony, we urge a favorable report. I'm happy to answer any questions you may have.
Thank you. We also have Ben Dubin.
Good afternoon. My name is Benjamin Dubin. By way of background, I'm a father of a profoundly deaf daughter. I served for 24 years as vice chair of Baltimore County's Commission on Disability and also at one point chaired the Governor's Office of Deaf and Hard of Hearing. So this issue is really important to me. The slides, the pictures that you saw of the trains and the LED displays were taken by my daughter. They go back to perhaps 2015. She rides a train frequently between Baltimore and Washington. I think we've got two issues here under ADA. The public transportation, a municipality or a state is required to make them accessible. And everybody thinks of accessibility as somebody with a physical disability, but this is an effective communication issue, which is also part of ADA. It's important that these audible or signs be available on the train and the buses, and light rail, so that people know where their stops are. This issue began sometime back in 2015, which I brought it to the attention of MDOT I've got correspondence which goes back. It says we'll do this in the next 2 years. This was in 2018. In 2019, they said things again. This is 2026, and the signs and audible descriptions and real-time captioning is not there, text-based announcements. So it's important for the safety of our passengers that we don't discriminate for individuals who are deaf and hard of hearing. There's some 1.2 million Marylanders aged 12 and above who are deaf and hard of hearing, and 700,000 Marylanders aged 12 or older who are deaf and hard of hearing. In addition, there's about 116,000 Marylanders who have sight impairment. So I urge the committee to give a favorable report to this bill. Thank you.
Thank you. We have a question from Delegate Stein.
Thank you, Mr. Chair, and thank you, Madam Vice Chair, for bringing this bill. And my question is for Mr. Ben Dubin, who's a constituent and with whom I tried to work on this issue. And so, Ben, I just want to ask you this. Isn't it true that you and I had several meetings with MTA on the LED issue going back years and really to little avail?
Yes, I've tried to pull up some of the correspondence that I've had between you and phone calls with MDOT, and I believe it goes back to 2015. Fortunately for me, I'm down in Florida with 82 degrees weather, but I have my laptop with me, and I generally have saved all this information.
Thank you for your advocacy.
Delegate Healy.
Thank you very much, Mr. Chair, and thank you for the bill. I think it's a great idea. I mean, it's necessary. It's actually obligatory, and it should already be in existence. I wanted to ask you if, in your research on this, if you had looked at any of the other transit systems in Maryland and what they do, and if they're in the same boat, like WMATA or some of the others.
Yes, I've been working on this issue broadly for a couple of years in general. So I actually have a report for everything from countywide for every county and disability services throughout the state. Do we have anything directly from WMATA? No, I mean, this bill, I don't know that we heard from WMATA. I
know your bill is only about MTA.
Yeah, about MARC and MTA.
I understand that. I just wondered that in your research.
And I'm not sure why we didn't. Because,
or even in other states.
Yeah,
I mean, is this a generic problem across?
Yes, no, this is something that's required by federal law. As you said, obligatory, and other states are doing it better than we do. Not everybody does accessibility as they should, but there's really no good argument to put this off or not to do it. I think one of the big issues that according to the favorable with amendments that I'm sure you'll read from MDOT, they're just saying it would take a lot of money to replace these and that many of their buses and their trains do not have these services. In fact, the majority of them do. They just haven't been maintained. And so just having them move forward with making sure that their new transportation systems have these going in the future is not quite enough. What they need to do is actually maintain the ones that they have.
Yeah.
So at least that much coming from this bill. And again, we didn't really talk to WMATA on this, but right now this is what we're doing.
I think it's really important. I just wanted to see if we could make it apply to everybody.
More expensive?
Well.
No, I'm with you. I'm 100% with you. Thank you.
Delegate Lewis.
Thank you, Mr. Chair, and thank you, Madam Vice Chair, for bringing this bill. May I just say that having visual and auditory signage, it helps people with disabilities and different abilities, but it's actually for all of us. And that's a great thing about the Americans with Disabilities Act. All of the amenities and the services and supports that assist folks with different abilities actually helps everyone. Okay, that's my soapbox. But I just want to make that clear. This isn't like some disability service. This is for everyone. And my question for you, for the good delegate, is are you aware that there are technologies that might be adoptable that could include not only visual and auditory, informational signage announcements, but could also help with, there's like AI tools, to help with speed control, say on a light rail, or bus stop enforcement at a bus stop, and that there may be opportunities. Did you talk with MTA about any other options that are out there in terms of new technology?
So I didn't talk about bus lane enforcement, although that's very, very important, Delegate Lewis.
Should always be talking about bus lane enforcement.
Under the scope of this bill, what we did talk to them about and what we tested as a team is the apps that are available to find your way, and the name of the app that would. There's a transit app, but then there's also another app that's not associated at all with Maryland that a lot of folks use. I asked specifically some of the folks here that have testified before you today how well that was working for them. And particularly with the Federation of the Blind, they said they really do have difficulty with those apps sometimes. So it's not really enough. Initially, when finding out about that technology, I thought, well, maybe all we had to do is require that everybody understood that this was out there and do QR codes and get the information out. But then to hear that they're not really working very well for the people that need them the most, I wasn't comfortable going that direction only.
Great.
But yes, we've done some research into that kind of technology.
Thank you, Mr. Chair.
Okay, I do not see any further questions. That concludes the bill hearing, House Bill 733. We'll turn to House Bill 668.
Thank you.
Delegate Captain Morgan, on behalf of the St. Mary's County delegation, prohibition on standing an inherently dangerous highway.
Thank you, Mr. Chair, Madam Vice Chair, Todd B. Morgan on behalf of St. Mary's County. I'm back again with a dangerous highway bill. As a preface, during the interim, Patrick and I worked on this extensively to try to get everything cleared up according to statutory law now, so I will make the presentation. The county, we the St. Mary's County delegation is pleased to present House Bill 688 to improve both safety for both motorists and pedestrians on our local roadways. The legislation authorizes the county to prohibit individuals from standing on a roadway, median, or intersection that the county determines to be inherently dangerous due to its design or accident history. St. Mary's County is a very large rural area with commercial development concentrated in a few town centers. In these areas, typical intersections along state highways often include narrow or raised concrete medians, limited shoulder space, and a few sidewalks or marked crosswalks. Speed limits on these roads are 40 miles an hour or higher. On major state highways, posted speeds of 55 miles an hour are frequently exceeded on a very regular basis. Several of these corridors have experienced a significant number of accidents. As traffic volumes continue to increase on our rural highways, the county has growing concerns about individuals standing in travel lanes or medians, particularly at these busy intersections. While traffic enforcement discussions about automated enforcement continue statewide, thank you, Delegate Guyton, for your bill today. Preventing dangerous situations before an accident occurs in the most effective way to protect both drivers and pedestrians and to keep traffic moving safely. There are specific intersections within our county where high traffic volume, narrow medians, or limited shoulder space create hazardous conditions for anyone standing on the roadway. Over the past 2 years, the county has pursued broader legislation to restrict roadway safety and solicitation as a safety measure. Despite a 2024 opinion from the Maryland Attorney General concluding that content and neutral restrictions are permissible, those as measures did not advance. House Bill 688 takes a narrower safety-focused approach. Rather than addressing the solicitation generally, it allows the county to prohibit standing only in intersections that are inherently dangerous due to their configuration or documented accident history. This common sense measure prioritizes public safety and provides the county with a practical tool to reduce preventable accidents and protect everyone on our roads. We respectfully respect the favorable report.
Thank you, Delegate. And I just want to thank you. I know this has been a multi-year effort working with council to try to come up with something that we think will withstand constitutional scrutiny. So really appreciate your efforts on that. Are there any questions on the bill? Delegate Foley.
Thank you, Mr. Chair. Thank you, Delegate, for the bill. it's kind of funny that we have to pass a bill telling people not to stand in a dangerous road, but whatever. Thank you for bringing the bill. But I do have a question. Is there, and you know, I didn't see it reading the bill, maybe I missed it. Is there an exception if there is, for example, an emergency, someone is, you know, has to flag down a car, or they, you know, for some reason they have to get out of the car or out of the vehicle, and it may require them to stand on the shoulder or the median for a period of time?
You know, this bill deals specifically with roadway solicitation. If somebody has an accident, has to go outside, I'm not worried about that. The county's not worried about that. It's the panhandlers walking around with their hat, you know, I don't have a home, please give me money.
Oh, sure.
And that's what this bill specifically is trying to address.
Yeah, okay, all right. Thank you.
Thank you.
Any further questions? Delegate Lewis.
Thank you, Mr. Chair. Thank you, Delegate. This morning, I remember, I think it was this morning, debate on the floor about a bill decriminalizing or updating or repealing the use of the term vagrant for some historic reasons. Are we talking about prohibiting folks who are unhoused, homeless, in some sort of distress? Is that what the focus is? Is that the concern in St. Mary's?
The focus of St. Mary's is that there are 2 or 3 major intersections in the county where people perpetually are out asking for money. What their status is, I couldn't tell you. I just see, you know, please give me money. You know, they could say they're homeless, and then people have said, well, they just get a car and drive away. I can't testify one way or the other on that one. I'm just saying these intersections are inherently dangerous, and we would really think it's a safety measure to not have people walking up and down and standing in the median asking for money.
Thank you, Mr. Chair.
And Delegate Morgan, a bunch of counties have laws somewhat similar to this, at least on their surface, but there has been case law bringing those into question. And so you've been working to come up with one for your county that we think is consistent with case law. Is that right?
Yes.
Okay, so you just want what other counties have, but in a constitutional way.
Well, what Patrick and I have discussed, and I think he might be better to do this than me, is that there are a number of counties who have these provisions, but simultaneously not all the provisions are the same. So where we are today, and Patrick, correct me if I'm wrong, we have tried to model this to the best legal standards possible with federal and state law today. Have I hit the nail on the head?
I think he's giving you the thumbs up. Okay. I don't see any further questions. That concludes the bill hearing on House Bill 668 and all the bill hearings for today. So just a reminder, tomorrow, Friday, we'll vote after floor sometime, so keep an ear out for that. The following Friday, we do start bill hearings on Fridays until we get to crossover or run out of bills. So please plan your lives accordingly. And in terms of subcommittee announcements, Chair Foley.
Thank you, Mr. Chair. The Non-Energy Utilities Committee, Subcommittee will meet on Zoom at 4:20.
Chair Lewis.
Thank you, Mr. Chair. The Motor Vehicle and Transportation Subcommittee will meet 10 minutes after non-utilities ends. Please watch your phones for texts and your laptops for emails.
All right,
Thank you.
thanks, everybody.